and welcome back to Military Law Talks. So this is part 2 of my video on this midnight unprecedented order from the U.S. Supreme Court on these planned deportations of, well, they're gang members, they're terrorist members. And so let's take a look at some other opinions that talk about these same sort of deportations and previous opinions. And so let's take a look at that. Okay, so this is a previous opinion from the US Supreme Court, and this is the case that Justice Alito was talking about in his dissent. This is from the US District Court of DC. And so this was a previous case that went up to the US Supreme Court, and essentially it stopped the TRO that was in place by the lower district court. And so, again, it's concerning the detention and removal of Venezuelan nationals believed to be members of TDA. And it's been designated as a foreign terrorist organization. Okay, so in this opinion, it said essentially it got rid of the TRO, allowed the Trump administration to continue to deport these individuals, but said, hey, you're gonna have to give them some sort of like notice and a hearing. And oh yeah, it's likely that this district court in DC doesn't have jurisdiction because, and I'm not going to go through this entire opinion, but that the district court in DC doesn't have jurisdiction because historically how these cases are handled is that the individual who is being detained needs to bring a writ of habeas corpus. Essentially, where's the body? I have an illegal detention. So, hey, court, step in and get me out of confinement that I shouldn't be in. But that these individuals should be filing these habeas writs in the district where they're being confined, and they're mostly in Texas, so they are not in DC. So this lawsuit was filed on their behalf in DC, but these individuals aren't in DC. And so this opinion says like, hey, we need to follow precedent, we need to follow the law, and they need to file this case in the district where they should be. And then that gave rise to that second case in Texas that was pending at the Fifth Circuit that we just got this midnight order. So a lot of the same individuals, if not all the same individuals, I'm not exactly sure because they're not all named. They're now in this Texas case that we got this midnight order. But I do want to point out a dissent from this case, from this DC case. Okay, so I want to point out this is Justice Jackson, who, in many opinion, is probably one of, if not the most liberal member of the court, if you can kind of term it that way. I think liberal, right wing, left wing. I don't know. I think these terms are kind of meaningless. But anyways, so Justice Jackson is writing, and this is a dissent to that DC case, right? That said, hey, Trump administration, you can continue deportation. We're going to dissolve the TRO, but plaintiffs, you need to go file in the case in the district court where you are being detained. So like go back to court in Texas, not in DC. And so Justice Jackson writes this dissent, and I actually agree with a lot of what she writes in the dissent, and you'll see why. Okay, so this was April 7th, 2025. She says, I write separately to question the majority's choice to intervene on the eve of the district court's preliminary injunction hearing without scheduling argument or receiving merits briefing. Sound familiar? This fly-by-the-night approach to the work of the Supreme Court is not only misguided, it is also dangerous. Think about what she just said. So yeah, absolutely. But then, 2 weeks later, week and a half later, the Supreme Court does it again. And so I'm continuing reading from her opinion. She says, when this court decides complex and monumental issues, it typically allows the lower courts to address those matters first. Then it receives full briefing, hears oral argument, deliberates internally, and finally issues a reasoned opinion. These standard processes may not always yield correct results. Sometimes we get it wrong, right? And she continues to say, but when we deviate from them, the risk of error is always substantially increases. Today's rush to conclusion that those challenging the government's action can only pursue their claims through habeas is exhibit 1. Her and Sotomayor, the other dissenters to this opinion, says that they shouldn't have to just go through a writ of habeas corpus. They can actually also appeal the government decision through the APA. That's what they're arguing. And so she continues. She says that, like, hey, this is like a misguided. We didn't thoroughly think this out. She continues. At least when the court went off base in the past, it left a record so posterity could see how it went wrong. See Korematsu, arguably, in my opinion, one of the like top 5 worst cases of the U.S. Supreme Court. This was what allowed Japanese internment camps in World War II. So I agree with her. That's a terrible decision. But when more and more of our most significant rulings take place in the shadows of our emergency docket, today's court leaves less and less of a trace. So yeah, I actually totally agree with her. So Justice Jackson says all that, and I do agree with her. But then she joins with the majority of the court in this most recent midnight order. And so she totally, like, I mean, less than 10 days, right? I mean, yeah, what is it? Less than 10 days later, totally flip-flops and says, yeah, I'm going to join the majority in this, like, really dubious opinion released in the middle of the night. Well, because it supports like her objective. And so I thought that was an interesting, kind of really poignant. Again, like I said, I actually really agree with her reasoning, but then less than 10 days later, she totally goes back on it. So I thought that was an interesting, so that is to kind of explain part 2 of this video on this midnight ruling. And so if you like this video, please hit the like button. If you haven't subscribed to my channel, please do so and share this video out there. I have another video that I'm going to be releasing about, like, kind of like, how did we get here to this like bad precedent regarding these like TROs, and like, imagine in 2020 if the Supreme Court had acted with such haste and to stop the blatant constitutional violations that were occurring to U.S. citizens. So I'm going to compare and contrast how the courts are handling the supposed constitutional rights of illegal aliens comparatively and contrastly to how they dealt with the constitutional rights of U.S. citizens during COVID. So that's my next video. So thanks for joining me, and I'll catch you in the next video.